Before entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually and, unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's October 24th, 2025 free CLE webinar, Deposition Exhibit Preparation. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. Our webinar today is proudly sponsored by Horizon Premier Staffing. We are happy to have Jenny Barbosa to provide a few remarks.
Hey, I think this is my turn. Hello, everyone. My name is Jenny Barbosa. I am one of the partners here at Horizon Premier Staffing. Thank you so much for the opportunity to allow us to sponsor this great CLE. I hope everyone gets lots of good information today. So about Horizon Premier Staffing, we are a fairly new staffing company, and I'm sure you guys have heard about virtual staffing companies everywhere now. But the reason why HBS was created was because by me being in the personal injury industry for the last 11 years, and my partner, who most of you probably know, Karina de la Cruz, with my sister company, Horizon Legal Solutions. She's been in the industry for about 20 years. We realized the need of doing this business a little different. We're literally handpicking our candidates just like we handpick our clients. We're able to provide very low cost bilingual virtual assistants that can pretty much do anything a law firm or a business needs. A lot of them have great experience. A lot of them are lawyers or paralegals in their own country. So it makes it a lot easier for them to transition into the USA workforce virtually. If you guys have any questions, want to know more information about we can assist your firms, wanted to also clarify that by no means we're trying to replace you guys. You guys are definitely the motor of every firm. We're trying to make it easier for you guys and finding help so that you guys can focus on more important tasks and get the less busy work to other people. So if you have any questions, want to know more about how we can help, please reach out to us. I'm going to put my contact information in the chat, but I'm sure Diana maybe can also share it. You can also reach out or look for more information on our website, horizonpremierstaffing.com. And one little last note is that we also offer a referral program. So if you send us a client and that client hires a virtual assistant, whether it's your own firm, a friend of yours, any business, after one of our VAs it's hired and placed for at least 3 months, then we will pay you a $200 referral fee. And that's for each VA that gets placed. So please spread the word. If you want to make a little extra money on the side, if you need more information about it, please, please, please reach out to us anytime.
Thank you so much, Jenny. Thank you so much. And I will now turn it over to FRP Enrichment Committee CLE Subcommittee Member Bonita Smith.
Thank you. The Florida Registered Paralegal Enrichment Committee invites all of our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there you will find helpful tips and announcements of upcoming events and our monthly webinars. Sheila Grela is a senior paralegal at Bullcoulter. She is an active leader in the legal community through the San Diego Paralegal Association and Women in E-Discovery, and frequently writes and speaks on technology, professional development, and durable skills for legal professionals. Sheila is passionate about mentorship, advancing paralegal education, and helping legal teams build stronger cases through the smart use of technology. Thank you, Sheila, for presenting today, and I will now turn it over to you.
Great. I know that I really like working with the committee. And one of the reasons I like working with your committee is that I feel like you're so supportive of the paralegal as an industry. And I want to thank Jennifer Finch, Diane Kellogg, and Jenny, who I just met today, for inviting me today. I appreciate it. Of course, I'm putting up the normal disclaimer, and I think we've already kind of gone over it. And I am going to try and rush through it. So there's so many things that are going on here that I don't think my bio is important, but you can get a laugh at the bobblehead that was made with AI. My husband went around at church that day telling everyone, I'm married to a bobblehead. So it is fun to use your AI, and I'm working on trying to get a future session with the FRP on the use of AI. So this is a whole lot of information and we can't get through everything. You have a lot of slides, and what's going to be happening is that many of the slides we're not going to go through individually, but they make up a nice reference packet for you. So one or two of these goals are obviously a lot to learn in and of themselves, but I want you to remember things like when you're about to do the deposition, think of it as you're about to start the record button, and you got to be ready for that. So let's consider some of the things that make up the purpose of it, purpose of this session, which is to understand what preparing for depositions looks like from the perspective of actually working and getting the exhibits ready. So when you're talking about compliant exhibit preparation, there are lots of things to discuss. You want your exhibits to be clean, you want them to be complete, and you want them to be consistent. So let me repeat that. It's kind of a short checklist for you to remember: clean, complete, and consistent. So we're going to be talking about what it is like to work with exhibits. And these are some of the things that are make up the components of actually getting the exhibits ready. Depending upon what you do, you may or may not actually take part in portions of this organization. And the reason that sequence is so important is because the attorney's strategy when they are asking the questions many times depends upon how the exhibits are set up and how their outline is set up. So the way I always think about it is if the attorney has an outline and they put the exhibits in there, it's really important to make sure the exhibits are laid out for him or her in such a way that they could easily pull them out to hand to the witness and the court reporter, or to have I kind of hate this term, but to have the exhibit bailiff place it up in a virtual environment. And the other thing to remember is you're always going to run into exceptions. And when I mean exceptions, I mean things that are not necessarily normal for you to deal with. So if you are suddenly working on a case where there is a huge issue about a video that you're going to have to play to the witness, that is something that you want to work on in advance, whether you're doing it in person or virtually. Not being able to play that video fast and easily could be a problem for the attorney because you don't want to delay the deposition, and you also don't want to take any of the attorney's time or the witness or anyone else's time trying to fix a technical problem. So your goal is also to make sure the technology works sufficiently and easily when it begins. Does anyone have any questions? Because you can ask questions as we go along. So now we're going to talk about what kind of things you might be pulling from the file to create exhibits, depending upon the kind of case that you're working on. Many times, the first question that I ask myself is, who is this witness? And what kind of things do I have to provide the attorney to make sure that they know what this witness's background is or what's going on? And many times I will have a huge packet that I've given the attorneys, and it's never a shock to me that they're actually never not used as exhibits. Generally, the only thing that gets used is a CV or a resume, but very little of the other things go in. If I have a LinkedIn profile, unless there's something they want to ask the witness about in the LinkedIn profile, they generally are just looking at it to get information about the witness. So this is an important element of preparing for the deposition to assist the attorney. If the attorney gives you an assignment of help me by finding potential exhibits for this upcoming deposition of a witness, and let's just assume it's a case that has more than one element in it, and for some strange reason, this is the third volume of that person's deposition, and there have been numerous declarations done by this witness. These are nice checklist items. Do you have a prior deposition transcript? Do you have anything that would be a declaration from that witness or about that witness? Now, about that witness is something a lot of people forget to address. If you have a huge case, the question needs to be asked, what happened to where we've had the other people in this case talk about this witness? So, and a good example is the plaintiff's expert witness went forward. This is the defendant's expert witness. So you want to make sure that your attorney has the information about what was said about this witness that he's about to ask questions about. So even though they were in the deposition, it's still helpful to have that portion of the transcript pulled out for them and placed in their preparation material, showing what was said about the other witness that you're about to depose. So even though it can be very time consuming, it is important to go through with the attorney after you've gotten the exhibits together, that there isn't another person or another element of the background of this witness that needs to be investigated. Now, I have a question. Oh, how do you handle Zoom exhibits when the attorney is very technology challenged? Number one, it's not possible to tell someone that their technology understanding is not what it should be, and then get them to trust you. Okay, so even if they are technologically challenged, you are going to need to talk to them about making sure that things run smooth for them. So if you do it from that perspective and ask for a dry run, 2 or 3 days before. Almost every court reporter that I know of will allow a practice session. So 1, definitely a practice session. 2, definitely talk to them way in advance of the practice session about how are they going to call out the exhibits. So a good example would be if you are told that you're going to have the contract brought up, and then you're going to put it in the chat so everyone has a copy, the attorney may say the deponent is going to download it and look at it, but I want you to go to the page with the signature on it, or I want you to go to paragraph 15. All of those things, if you know it in advance, are not only helpful for you to playing deposition bailiff, but also help the attorney focus on what they're going to be doing with the exhibit. Now, in some ways, this is a lot like what you might do during trial testimony, because you always are presenting things. Oh, I love this tip. We have someone who actually has dealt with this, and their suggestion is to stand behind the attorney and have and tell him where to click here, select this, make it bigger, and basically be with them the first time they use it. And I think that what you're saying is because you're having to tell them all the time, it feels like you're doing more than you should have to. And so my suggestion would be to talk to them and say, you remember how the last time during the deposition, I, helped you with actually presenting the exhibits yourself? So let's talk about other possibilities. I could be an exhibit bailiff during the deposition, or perhaps what we want to do is to instantly provide the actual entire exhibit to everyone via a link, so that everyone can open it up on their computer on a second screen and be looking at what you want. Yes, that is correct. Jessica, David pointed out what a deposition bailiff is. It is someone that allows the attorney to focus on his questions. And the reason that that's a really important element is because with virtual presentations, it's one more thing to do. Attorneys are so used to having a stack and handing it out. So whatever method they presently use, they have to get used to doing the virtual. So one of the things that I find to be helpful, besides doing a run through, is to ask the attorney how they're going to identify the exhibit. So, for example, they might just say, hey, we're going to talk about the May 4th, 2020 contract. Not a lot of information there, because if you've got 1 million pages in your database, which pages is he talking about? So sometimes it's a matter of giving the short description and the bait number that it starts with and the bait number it ends with. Now, if you're going to have someone provide thorough descriptions, the best way to deal with it is to make sure you've made a short exhibit list where the descriptions could easily be used by the court reporter. And it also serves the attorney in case he goes back and forth, and he can write the exhibit numbers down. So there are lots of different things that are listed in the slides, and talking about how to do an exhibit list beforehand to help the attorney be organized and to help you make sure everything is put out. Okay, I think we've answered everyone. Oh, no, we didn't. Yes, someone pointed out that doctors use this step as a scribe. I love it. They're in the room and they assist with the computer. that is a very valid point, that in our industry, sometimes we don't want to talk about how there needs to be a second person to help with things. So the other thing we're going to get together for the deposition is we're going to get discovery material. And the reason we need discovery material is obvious to everyone that works in litigation. But one of the things that's on here that isn't remembered or focused on is privilege log entries. So if your opposing party has given you a privilege log and 100 of those are list the witness that you're about to answer, the attorney may be asking questions to confirm that the entry description means it was truly privileged. Or they just might want to have information for themselves about how much was this deponent involved in conversations with the attorney, just for their own edification. Okay, and I'm going to speed it up just a little bit. When you're talking about document identification and retrieval, everyone's methods are going to be different based on the software that is in your office, the methods that each individual has been taught, and also what's happened in the case already. So if your attorney is subbing for someone else, they will need to follow what was previously done, not do things their way. So I would definitely look at the issue of master exhibit list as a first step before you take the first deposition. So the master exhibit list is a distinct list that everyone agrees to and that starts with one and always stays in sequence. And the reason why it's important is it makes it easy for everyone to know what depositions have gone forward with what exhibits, because all of that information should be on there. So, and as to document reports, I once had an attorney who had a very small database, and he had to do the arbitration all by himself. So he literally had me run off reports for each witness with the information being in chronological order, and he would use that to prepare his outlines for the arbitration sessions. So document reports out of databases are a good way to work on determining what exhibits you want. Anyone have any questions? So this is a workflow, and the only reason I want you guys to note it is that if you haven't ever dealt with a volume of documents, this is a good kind of checklist to realize, okay, these are the things I have to do. These are the things that are going to be going forward. Okay, so the other unique thing that happens a great portion of the time is that a huge amount of effort has to be made in preparing for, I call them PMKs, other people call them PMQs, lots of different things. But what it really means is a company or corporation designates someone to testify, and generally the notice has all of the elements, all the things that they'll be questioned about. So if you are working on determining what exhibits you might want, the depo notice will have the PMK categories, and they should be clearly listed. Now, what I've done before is to actually sit down with the attorney about when they assign me, hey, we want you to help find exhibits. Hey, here's the list of what you have. Can we talk about what kind of items you're looking for, what you expect to be found, and more importantly, how we want to organize this so that it's easy for you. So definitely meeting with the attorney and doing your communication and due diligence is really important. Now, as to documents per topic, sometimes it's easy because the description tells you the type of documents, but there are also times when it doesn't. And there are also times when the attorney hasn't determined where this information might be. So you kind of need to make sure there's a lot of communication when you're taking care of PMK depositions. Expert witnesses. When you have expert witnesses, you know that getting all the material together of what was produced about the expert and from the expert is a really important point. And if at all possible, if the parties can work on it together and produce the documents before the deposition, that is a huge help. And this little checklist is not everything, but it gives you some kind of idea of what you might be wanting to look for when you start the preparation. So if this particular expert is a scientific expert or is someone who is highly published, you might be taking their CV and sending a note to the attorney saying, these are all the items that they have listed as white papers or other types of publications. Do you think you can tell me which ones you want pulled, or do you need them all? So again, communication is a thread through preparing the attorney for these kinds of events. And for the attorney, giving instructions to the paralegal about experts can seem a little daunting because in your mind it's easy. It's the expert. Just get me his stuff, get me her stuff. But sometimes it's easier to take a moment and talk to whoever's doing it for you and tell them what you're working on to get the information to defend or prosecute the case, whichever it is. Because if you have that, it makes it easier for you to look for the documents. Now, I went the wrong way, sorry. Okay, so this is the timing issue with regard to, do you want to try and get the documents beforehand? So it's definitely something that's on your list of what you should ask the attorney about. Do I really want, we going to try and get everything in advance? What are we going to do it? And I think the issue with experts is that everybody doesn't want to waste their time reviewing the file in front of an expert that is being paid. So almost everyone that is in the legal community cooperates on this issue because it's just not in anyone's best interest to expend extra time waiting for someone to be doing review of documents as the deposition is ongoing. So this list is just a nice quick reminder of sources, and the Florida Handbook on Civil Discovery Practice is available on the Florida State Bar. It is very easy to find and it's very helpful. I would definitely recommend, if you've never prepared an attorney for a deposition, or if you're a new attorney, for you to look at that because it has a lot of basic information. And if you are doing things in federal court, the way to get information about federal court, there's more than one method to get an understanding of the overview, but my favorite is Judge Battaglia in the Southern District of California. Explains so many of the discovery components of preparing for trial in his disclosure and discovery practice book. It's very helpful to get a good understanding. So if you have federal cases, don't hesitate to look for the federal resources, okay? You definitely want to do that. Post-deposition follow-up. This is another item that's communication. Just because the deposition is over does not mean the work is over. And it also does not mean that the attorney might not have additional things that come out of taking that deposition, especially with regard to we need follow-up subpoenas. From taking the deposition, is there a reason to ask the client for more documents? A new name came up during the deposition that you've never heard of. You have someone look and don't see that name in the database, don't see that any emails from that person. So you have to call the client back up and go over what they know about this person and how were they important and were they with their company. All of those questions can come up from the deposition. And the reason that it has to be on a follow-up list is because the day before the next deposition is not a good time to be rushing around trying to find out information that you were missing from the last deposition. So the other items are when you receive the transcript and you want to talk to the attorney about what is he going to do with it. Who gets a copy of it? Were there any problems during the deposition of objections or evasive answers that need to be followed up on? If so, talking to the attorney about, okay, so can I calendar a reminder for you to do meet and confer with opposing counsel? What can I do? Do you want me to pull out the sections and give you a report of what was said when that they were instructed not to answer? There are a lot of things that you can do, but the most important one is to ask them what they want done from the completion of the transcript. And what the witness agreed to provide is a pretty normal follow-up thing, but you'd be amazed at how many people don't end up remembering to go back and get that piece of information or that email or text message or whatever they promised to provide during the deposition. So we're at the halfway point. If anyone has any questions, let me know. We're just looking here at the difference between remote and in-person preparation. The main issue is, regardless, making sure everyone knows what the protocol is. How do we get this done? So if it's remote, there's the things that you want to take care of. And as to private chat with counsel, I'm not a fan of that. I'm always worried that I'm still going to be in a open room. So I don't generally like the private chat for counsel. You can inadvertently type it in and it goes to the whole group. But a lot of people really like that. And if you are going to do that, it would be my recommendation that you have the court reporter service who's providing the virtual instead provide a breakout room, and that breakout room is clearly labeled and clearly shows who is or isn't in it at any given moment. And that reminds me of the in-person has one advantage over remote that people don't think about, and it's always fun. And that was, why do we need to ask if the person who's being deposed is in the room by themselves. If the attorney from the other side isn't with them and they're, in Japan or Singapore or someplace, and you want to make sure no one's sticking notes in front of them, no one's giving them coaching. So it is a prevalent discussion point about how do you confirm that no one is in the room where they can influence or change things with the deponent. And the other big deal is exhibit transport. If your attorney is going out of town and you're needing to have physical copies of the exhibits provided to him, it is my suggestion that you have them printed before they get to the court reporter. So if at all possible, if the deposition is going on Thursday, you've given a share file link to the court reporter on Tuesday, and they have printed everything that the attorney will be using and handing out. So they would have 3 different stacks, and the attorney would use it to, choose whether or not he's going to be asking the questions about that exhibit. If not, then he doesn't provide it to opposing counsel and goes on to the next. And generally, most attorneys may have a huge stack and they end up only doing a little bit, very little bit of the exhibits. They just really want the ability to have the information if they need to have follow-up questions, if there's additional information. So confirming the marking protocol, that's the same issue with the master exhibit list. You want to work on it. Here's the ethical safeguards that is a huge checklist, okay? And many of these things are pretty obvious, but not all of them are. So be careful that every exhibit that you have prepared has been looked to make sure that there's no privileged content, or if it's supposed to have been redacted, that it has been redacted. Those are the kind of things. And the item on here that says use clean annotated free versions, that is on here because I actually was in a session when a young attorney, very young attorney, like 2 years in, was taking the moment to put up the exhibit and inadvertently put his copy, which had highlighting and notes about what was going to be asked to the witness. So again, be very careful that you know that what's in there that you're going to be pulling up is not tainted in any way. Okay, so here's another just quick checklist. This is basically an overall view of what you're doing. You're finding all the relevant documents. You're organizing exhibit sets. And that goes back to what we talked about before. Every attorney is different about how they want it. Then you want to be very sure about exhibit quality. So my example for exhibit quality is always the same. If your attorney uses the wrong exhibit, i.e. it wasn't the signed copy, it could pose an evidentiary problem later. So you definitely, if you know there's more than one version of a particular document, you definitely want to have a conversation about which is the relevant copy that the attorney wants. I've had cases in the past where there were 15 different drafts of an agreement, and having to go through each and every one with the witness required that the red line versions were printed and that it was identified clearly by the date, including many times who forwarded it via email. So all of those things are very important, but you have to know that not every case has those elements. You need to know what's important about the exhibits you're providing. If it's medical records, many times it's about making sure which doctor did this come from. And so tip on medical records. Most medical records do not come with a Bates stamp number on them. You just get an electronic copy and it looks ugly and it's got lots of things all mixed up into one big PDF. You definitely want to take the time to mark it as exactly as you receive it, make note and track it. And then when you're making your exhibits, you can say where it came from. Because if you have someone who has been seeing a lot of doctors or has seen a doctor over a long period of time, it's very important to be able to identify where those documents came from. Okay, so here's a few more tips that you can put in your best practice thing. Number 3 of coordinating with the court reporter seems like a no-brainer, but you'd be amazed at how many people don't know how the court reporter does things before the deposition starts. It is important if you've never used that court reporter before, and it's a Zoom that you do a practice. Okay, here's a few suggestions of things you can use for actually preparing items. And you've got all these in front of you. There are plenty more. I don't think we have time to go over them, but if you have any questions, let me know. I am providing my email at the end. Here is a timeline, and it's overly simple, but it helps to know, you don't want to wait until the day of the deposition to be doing things. So figure out your attorney's cadence, plan using timelines, and I'm sure I'm going to get someone pointing out that attorneys don't like to start 10 days beforehand. Oh, you're right. I should have changed that. I did find that there is a 2024 Florida handbook, and I knew that and should have changed that notation because I did find it. And everyone, please note that the book has been updated to 2024. And someone asked yes, everyone will receive a copy of the presentation, and a PMK stands for person most knowledgeable. PMQ stands for person most qualified. Many people refer to them as the designated representative. And John, you asked about bringing the privilege log. No, it was not bringing in the privilege log. It was giving the privilege log to the attorney so they can determine if there's anything that comes from looking at their involvement in the privilege log that they might need to ask questions about. It's almost never an exhibit. It's just preparation material. So even though we don't distinguish in the conversation here the difference between preparation material and exhibits, there's huge amount of exhibit preparation that involves providing things that will never be exhibits, but that help the attorney prepare. Okay, let me see. I've gone back. Oh, it's Judge Battaglia. And it's the Southern District in California, and that's for federal. I'll make sure that I put that in some supplemental information for everyone. And what is the difference? Okay, Barbara, there is no difference between a PMK and a PMQ. It's generally what district and what standard of practice that area actually uses to talk about that. And so it's just a term of art, to be honest. Okay, so backup copies. Be very careful. Make sure you have a backup copy of everything in case the worst happens. I've had the worst happen. An attorney traveled to Colorado. The FedEx with all of his exhibits were sent to be at the court reporter the day before. never made it. Okay, I had a backup plan and we used it, but something is always going to go wrong the more complicated it is to get the deposition going. So use the cases that I'm about to present about problems that happen during depositions as a means to audit your current processes and potentially train new team members and make your depositions bulletproof in the sense that you know what you're going to do and it gets accomplished. So here is just kind of an outline about what they are. And we are running low on time, so I'm going to go a little faster. Failing to practice your share exhibits in advance, the impact is pretty obvious with time and problems. Improper or inconsistent exhibit numbering, I've seen this happen numerous times to where in a future deposition, someone refers to a number from a prior deposition and they didn't know there were two exhibit numbers 25. So it's really important that you're consistent and that someone is monitoring the master exhibit tracker. 3, presenting poor quality documents, that can be a huge issue. I've seen people have a photo and by the time it gets down to be in the deposition, they're putting in front of our witness and our witness says, I can't tell what that is because it was processed so much and was black and white and just didn't provide the information. You want the best possible copy to be placed in front of the witness and eventually to be used at trial. We talked about this already. You don't want privileged or internal annotations showing up on the screen or on the copies that are handed out. And this one is important in the sense that a lot of court reporters can easily get confused. So most attorneys are really good about this. When they hand the copy to the court reporter, they'll usually write whatever number it's going to be because they'll have asked them, what number is this exhibit? Or, you know, give me the next exhibit number if they've lost track. But they'll put the number on it in the corner for the court reporter. But it is really important to make sure that you're referring to the exhibit as the number that it is during the deposition, and that is what is used on the master list from there on. The blurry screen or the problem with bad PDFs, I think pretty much it's like doesn't happen all the time like it used to at one point, but you definitely do want to be careful by practicing. This goes back to that one. Disorganized exhibit footer or the wrong document. You got to be careful. You need to know how you're naming them and be standard. The lesson with the standardized name formatting, that format comes from someone whose only job in the world is to be a hot seat operator. Okay, they're the person who sits in the trials and pulls up the documents. They suggest early on coming up with a standardized naming format so that everybody has no problem determining what that document is. Now, this format is just her suggestion, so you would be using whatever internal system your document management or your team uses. Oh, this happens. You don't want them to lose track of exhibits. Did I put that in front of the witness? And what happened? And, you know, the reference to the Exhibit 6 says it's an email, but when I look at Exhibit 6, it's a contract. Monitoring it while you go is what the attorneys generally do to avoid this. But it's still important to check when you get the transcript and make sure that things are matching up with the master list and that they're correct. Okay, huge list of what you do to prepare. This is just a checklist, and so we're not going to go over it. And yes, you're getting a copy of the slides. Here is a quick example of what a simple master list might look like. And this section is because the last time I taught this, I had a lot of people who were having trouble understanding the difference between 3 ways of marking exhibits. So exhibit branding and numbering is for the purpose of labeling things. So when you're numbering, the best practice for sequential when it's trial exhibit is right there. And footer branding is generally the way most of them do it. But the first consideration is, what does that court want? You don't ever start marking your trial exhibits before then. So what that means is knowing what the local court requires will help you during your depositions by making sure you're being consistent about how you're naming them. And here's the 3 different things. As you can see, we've got the trial exhibit branding here, we've got a bait number, and we have the stickers. Okay, and here's a short sheet list in case you are trying to determine what the prefix might be for certain types of exhibits. And the best practice for naming exhibits, and that is that you have leading zeros and that you have enough. So most cases never go over 4 digits for a trial exhibit, because having 10,000 exhibits doesn't happen very often. But there are huge multi-district cases that do that, and generally they come up with some sort of system as far as how many digits it should be. Always avoid symbols and stick to your prefix and number format, whatever you're using. You want to locate things fast. And here again is a real quick overview of exhibit stickers. Okay, yes, a corporate representation. I'm changing subjects for a moment. The PMK, PMQ could also be referred to as the corporate representative depot. However, because many of the designated or PMQs, PMKs are not from a corporation, they might be a partnership, they might be any sort of thing. They could even be a church. You usually use one of the short names and not corporate rep. Okay. So here's an explanation about the court reporter exhibits. Keep it for your files. And we got 10 more minutes, so I'm going to try and wrap this up real fast. You have a slide on all of them, but this is an overview of what the format looks like. Okay. If you can't remember, you'll have a cheat sheet that you can go to, and that gives you some idea of how that works. Now, communication, thoughtful questions are really the thing for the day. And I had, when I was preparing this, an attorney talk to me when I asked about it. They said, well, I prepare my own exhibits. And my response was, well, then what can I do for people who have attorneys who prepare their own exhibits? And we came up with a list of, when your attorney says, I got it, what kind of questions should you ask? And these are pretty simple questions. And you can always have a response back, and that's what's in here, is what potential responses you could give them. Now, Ethical safeguards are really, really important. The best way to just remember it is label carefully, store securely, and always safeguard your client confidentiality. That's really pretty good overview. So no public access. This means that when you send someone a link, that link needs to be a secured link where if someone inadvertently emails it to an expert or someone who's not involved in the case, that person cannot click on that link and be in that material. Because when they click on the link, they should be getting to a zip file or some sort of file that's encrypted that they need a password for. So passwords are sent separately, another point for confidentiality and security. And here's a few more ideas for you. And this one is a pet peeve of mine. If you're so busy that the attorneys are putting things in one folder or they're getting confused and you don't know which copy is what, come up with a simple method for naming the documents to where people know, don't use it, don't produce it, it's work product, or it's my note copy. Whatever prefix you want, make sure you're naming them if they are that way. Okay, so reviewing for privilege is obvious, as well as data compliance. Now, when it says secure transmission, we're going back to the don't put it somewhere where anyone could actually look at it. Okay, I think I'm caught up with the questions. Post-deposition follow-up. It is really important to track all the elements of the transcript. Did you get it? If it was your client or someone that you're responsible for, have they signed it? Have they made any errata changes? Where are we storing all of these? And you want this all taken care of so there's no last minute scrambling to get everything ready when you're dealing with trial. And other things to consider are pretty obvious: monitoring the deadlines, keeping the errata sheets linked to the transcripts. And when you get the official original copy, if that is what happens, you definitely want in your tracking material to note that that's what you received. So if you receive an original and you have to send it to the client, then your tracking is going to say you send it to the client. And then when the client gets back, you say it's here, it's been stored in our file cabinet or wherever it goes. I know eventually, hopefully, they're going to work on this to where the actual originals don't have to be a hard copy. But right now, that is not the case. Video and audio recordings. I'm really talking about those few depositions where someone was videotaped and you need it for future use. Make sure you know where they are. Make sure you know that they're synced up and you know how to find it if you need to. Those are really important rules in order to make the video that your client paid for, which is usually extremely expensive, available. And signed. The court will ask, you have the original transcript? Yes. Is it signed? That's going to be a question, so you need to know that. Here is my email, and I would really appreciate everyone linking in with me. And we have 5 minutes, which I never managed to do. Does anybody have any last minute questions? Okay, well, here's a quick little chart that you can use at your desk for what you need to look for. And we have 4 minutes, so you sure you don't have no one has any questions?
And if not, Sheila, we just want to say thank you so much. And thank you everyone for attending today's webinar. The course number for today's webinar is 9475. Again, the course number is 9475. This webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit. Please self-report this course in the member portal. You will receive an email tomorrow via Zoom outlining this information along with the presentation from today. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is a completely confidential and free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.